Good evening, dear colleagues. I'm glad to welcome you on the webinar of the Ukrainian Arbitration Association. I am Olena Pripolinska, President of the UAA. And today we have a quite interesting topic to discuss. On 7 December 2022, just a few days ago, the French Court de Cassation issued its decision, we could say groundbreaking decision in Oschadbank case. And today, I'm very delighted that we will be able to discuss it with our guest, Philippe Pensol. Philippe is head of international arbitration for continental Europe and in Queen Emmanuel's, and he's based on firm's Geneva office. He has over 25 years of experience as counsel expert and arbitrator in international arbitration. He has dual qualification as French avocat à la cour, as well as English barrister. And different sources and rankings describe Philippe as a leader in his generation in Paris, possibly the leader, and one of the absolute masters in the field. I would also add that Philippe's firm, Queen Emmanuel, is a counsel for Oschadbank, and this firm has secured 1.1 billion award in favor of Oschadbank against Russian Federation. And actually, the fate of this award would be the main subject matter of the discussion today. So, Philippe, welcome.
Welcome.
Before we start discussing the Supreme Court decision, could you please briefly tell us about the arbitral award itself and about the Paris Appeal Court decision of 30 March 2021?
Yes, of course. So I was not part of the team that did the arbitration. It was my London colleagues, and they were among the first to bring these cases against Russia following the annexation of Crimea. And essentially, what they did is that they used the existing BIT between Ukraine and Russia as a basis for a claim for the expropriation of the assets located in Crimea. It was a novel idea at the time because, of course, it's an illegal annexation, which is not recognized, but nonetheless, it does produce effect from the BIT point of view. And so they brought this claim and they were successful in front of a very distinguished tribunal. They obtained an award worth 1.1 billion plus with interest for the expropriation of the asset of Oschadbank in Crimea, comprising, of course, the local branch, the underlying assets, the banking license, the buildings, etc. Russia did not participate in the arbitration. It just challenged the legitimacy and the jurisdiction of the tribunal at the beginning. When, of course, the award was out, it sort of woke up and started annulment proceedings before the Court of Appeal in Paris. Paris was the seat of the arbitration. And because annulment proceedings in Paris in international matters, as is the case here, have no effect on the enforcement of the award itself, Russia also asked the Paris Court of Appeal to suspend the enforcement of the award pending its action to set aside. The court decided that motion first, and it rejected it. As a result, pending the action to set aside, the award could be enforced, and Oschadbank, of course, took steps to enforce the award. But in the meantime, there was this action pending before the Court of Appeal. As you may know, in France, there are only 5 grounds to challenge an award, so it's very limited. It's jurisdiction, constitution of the tribunal, due process, the fact that the tribunal complied with its mission, but it's understood in a very narrow sense. It's essentially ultra and infra petita, and of course, the fact that the tribunal will not act ex aequo et bono if it has to apply the law, or the reverse. And essentially, that's it. And that the recognition and enforcement of the award in France will be contrary to international public policy. So the grounds for challenging the award were limited. Russia advanced several grounds, one of which being the fact that this treaty, this BIT, has a particular feature, was entered into around 2000, but in fact, its effects were retroactive. So the treaty itself entered into force at some point in time, but the effects of the treaty were way before the entry into force, and it applied to all investment made from 1 January 1992 onwards. That is a provision of the treaty, Article 12 of that treaty. So Russia seized on that article and told the court that because the investment was made before 1 January 1992, the tribunal did not have jurisdiction over the dispute, because Article 12 was to be understood as part of the conditions that would be necessary for the jurisdiction of the tribunal to be established. That was the claim of Russia. Of course, there were two types of answers to this claim. One is a factual answer, where in fact the investment does not date back prior to 1 January 1992, and where some of could be before, some could be after, and more importantly, the asset which was located in Crimea could not be an investment under the treaty before Russia took control, which was in 2014, as we know. So that's a first type of answer before the Court of Appeal, and we made it, of course. And another answer, more, let's say, even more sweeping, is that Article 12 does not pertain to the jurisdiction of the tribunal. It's not a condition to the jurisdiction of the tribunal. It is a question going to the substantive protection. Whether the investment is covered or not is a substantive protection issue, and as a result, it belongs to the merits of the case. And if it belongs to the merits of the case, it cannot be reviewed by the Court of Appeal, because in France, there is a prohibition for the Court of Appeal to review the merits in an action to set aside, and that is very firmly established. So we ran those arguments before the Court of Appeal, and we were very confident that the Court of Appeal would endorse them. To our surprise, and to my surprise in particular, the Court of Appeal accepted Russia's argument that Article 12 was a condition to the jurisdiction of the arbitral tribunal. They accepted that. They didn't look into the facts really, and that's not the job of a Court of Appeal, I have to say. And they also accepted, on the basis of what I would call a summary review, that the investment was made prior to 1 January 1992, and as a result, they set aside the award. We were, of course, shocked by that decision, which was, in our view, completely wrong as a matter of law. And so we decided to bring the matter before the Court of Cassation, which is the Supreme Court, and which can review the legal aspects of the decision of the Court of Appeal. And maybe I will stop there. Alina.
Yeah. Just several follow-up questions. First, probably why Paris, if you know, at least from your colleagues, why Paris was chosen as a seat of arbitration, and how? Because it's not in the treaty.
No, it's not in the treaty. This is ancestral arbitration. So it's ad hoc. As a result, the seat is fixed and decided by the tribunal itself. Oschadbank proposed Paris because, in my view, rightly, despite this unfortunate decision of the Court of Appeal, Paris was viewed at the time as an arbitration-friendly jurisdiction, quite predictable. There is a long history of arbitration awards being challenged in France in an unsuccessful manner. So the rate of annulment is very low. And in principle, it's quite predictable. If the award is set aside, there is a reason for that. And as a result, Paris was viewed as a safe seat in a way. So that's the reason why it was proposed and accepted, I assume, by the tribunal.
I remember last year when this decision of the Paris Court of Appeal appeared, it was like effect of a bomb. So why this decision was so vividly discussed by arbitration community, not only in France, but globally?
Well, there are a variety of reasons. First, if I stay within the French borders for the time being, what I just said about the predictability of the Court of Appeal is something which is very true, but in fact turned out to be less true for investment arbitration. There are a number of investment cases that have been brought before the Court of Appeal in Paris with mixed results. These cases went to the Supreme Court, and there were 5 of them when we initiated the Oschadbank appeal before the Supreme Court, the Court of Cassation, and 4 of them had been quashed by the Supreme Court, meaning that the case law, and those cases were all running more or less in parallel, meaning that the case law of the Paris Court of Appeal in terms of investment arbitration was a bit in a state of flux. At that time, the court was not very familiar with investment arbitration. It was very familiar with commercial arbitration, but less so, in fairness, with investment arbitration. And therefore, it attracted a lot of attention. The Oschadbank decision, as I said, was really, let's say, questionable, for want of a better word. And so many people wrote on it, saying some of them approving it, most of them disapproving it. So it attracted attention in France. That attention was compounded by the fact that there were parallel proceedings in other jurisdictions, primarily in Switzerland and in the Netherlands, with this, or in the UK, with the same issue being discussed for other cases. Sometimes it was Ukrainian claims, sometimes it was Ukraine being respondent, but the same treaty had been discussed by other courts, and none of them had agreed with the reasoning that was accepted by the French Court of Appeal. So the comparative law exercise was weighing in favor of an annulment or the decision of the Court of Appeal being wrong on its face. And of course, we had made those arguments before the Court of Appeal, but it dismissed it, saying the situation was different. So that was another reason why this decision attracted attention. And then, of course, there was the particular context of Ukraine and Russia, even before the war. It was a tense, and the amount of the award itself was a reason to attract attention. So there is a lot of factors leading to the legal community being very interested in this case.
I understand that part of potential Ukrainian claimants are also interested in this case and were quite concerned with this development, because the reason why the French Court of Appeal decided that the investment was made before the 1st January 1991, it's that it has certain like Soviet roots. Yeah, this assets. Could you tell a bit more about it? So why the Court of Appeal decided that it's like made before the date?
Actually, the court took into account the Soviet roots, but there was one aspect, one particular registration, I believe, in a certain register, which was dating to 31 December 1991 instead of 1st of January. And so the fact that the branch was locally registered at that point in time, and again, I speak from memory on this because I was more focused on the legal aspect, more the facts, but there was one aspect which attracted for some reason the attention of the court, and the court seized upon this to say, well, the investment was made before, which frankly makes no sense. As I said, first, because it's not an investment until Russia takes control, and second, because of course, when you run a branch, various branches of a bank, you keep investing, because otherwise your business will go down. So it's not like in 30 years, nothing had happened. It's actually the opposite. But nonetheless, the court was not concerned so much with the economic aspect of this. It seized upon some, let's say, legal formality that took place at the end of December 91, and that was good enough for the court. Yes, so there was.
Let's move then to the decision of the French Court of Cassation. So what the court has decided and why?
So that decision is very, very important because we challenged the Court of Appeal, and I have to give credit to my friend and colleague Jérôme Orchait. As you know, in France, there is a separate profession for appearances before the Supreme Court, Conseil d'État and Cour de Cassation. Jérôme is one of the best lawyers. He worked in tandem with us, and he argued the case before the court. And so he's part of that victory as much as we are. And we decided to challenge the decision promptly. So we asked the Court of Cassation whether the issue of the temporal application of the protection guaranteed by the treaty, the famous Article 12, belonged to the substantive protection, or was also part of the conditions triggering the jurisdiction of the arbitral tribunal. We asked that very question to the court. We had other annulment grounds, but this one was the first and most important. And we pointed out that the offer to arbitrate is found in Article 9 of the treaty and does not have any cross-reference to Article 12. It does not have any reference to the scope of application ratione temporis of the protection of the treaty, and therefore it could be read without Article 12. We also pointed out to the fact that the definition of investment itself did not contain that limitation. And so we told the court, essentially, we think this belongs to the merits. Can you please confirm it? Then we had other grounds of annulment, but this one was the most important. The court said, if the court said yes, that would be the end of it. The award would be quashed, and it will not be possible for Russia in another action to argue that the fact that the investment was allegedly made before 1 January 1992 was a condition to jurisdiction. It belonged to the merits. The decision of the tribunal would be final because it would be not reviewable. So that was the interest of raising this question. Of course, if the court had said no, then we had other grounds, more technical, which would have even if it were successful, enabled Russia to re-argue its case about the date when the investment was made before the Court of Appeal subsequently. So that was the key issue. Fortunately, and when I say fortunately, I mean in the interest of the law, rather than our selfish interest, the Court of Cassation agreed with us. And it said in extremely clear terms that neither the offer to arbitrate nor the definition of investment did have any temporal limitation to the substantive protection, that therefore the substantive protection of Article 12 belonged to the substance of the case, to the merits of the case. It said that in so many words, meaning that it was not reviewable, and it quashed entirely the decision of the Court of Appeal. So this is where we are now. We are in the situation where we were before the Court of Appeal rendered its decision quashing the award.
But my reading of the decision is that the case is remanded back to the Court of Appeal in a new composition. Is it correct?
That is correct.
And if so does it mean that the case will go for another round of judicial review, starting again from the Court of Appeals and going back to the Supreme Court? And what is the limit of case consideration? Is it de novo basis? Is the court bound by the decision of the Supreme Court? So how this would work? And why it's remanded back, actually, if everything is so clear?
It's remanded back because Russia had other means of annulment based on the tribunal not having complied with its mission, which were not decided by the Court of Appeal. We do not believe that these annulment grounds are very serious for a variety of reasons, but they are still pending. So it's remanded to the Court of Appeal in another composition, and it's for Russia to seize it. We are in a situation where we were before it rendered its decision. So all the briefs that have been, all the written submissions that have been exchanged before the Court of Appeal are still there. The court will have to judge on the basis of these materials. They will probably ask for a new exchange of briefs, of course, because the main argument that was put forward by Russia based on Article 12 of the treaty is now gone. We know now that this belongs to the merits, that this is not reviewable. So Russia cannot resurrect that argument and plead it again. It's finished. All they can do is pursue the other means of annulment that they had raised and that were not decided by the court. And this will take a few months. And then we shall have a final decision. And then, of course, Russia or us, but I think either party could go back to the Court of Cassation, but the court will be consistent with its prior rulings. So the aspect based on Article 12 is final, finished. The only part left is the remainder. And as I said, and without entering into the detail of the argumentation, we do not believe that this is, let's say, very promising in terms of annulment chances.
Just again to be clear, so the remainder was not decided just before the court took one argument, made decision to annul, and that is why the remainder was not important for the rest of the decision, right?
Yes, it was not decided. That's a specificity of the French system. If there is one argument that works, the court will not decide the others.
Okay, I got it. So it's quite interesting. Okay, and is the Supreme Court, if it's not the end of the story, yeah, Is the Supreme Court decision important for Paris as a seat of arbitration? Does it mean that Paris is a safe seat of arbitration for other potential claimants under the Russia-Ukrainian BAT, or not yet? We should wait
yes,
until
it
the
is.
end of this.
It is, because it takes care of the let's say the one argument which is very important, which was very important for Russia. This argument based on the temporal application of the treaty. Now the court has clarified that this is not reviewable. So of course you can win or lose before the arbitral tribunal on that basis. That's a different matter. But if you win, then the court will not review it. So it means that let's say the possibility for Russia to challenge an unfavorable award are very limited. And the case law is evolving. It's not only in this case, but in other investment cases. Now we have let's say, a more clear view of the position of the Court of Cassation, and it's quite in line with what the court has done for commercial arbitrations, with, of course, some specificities, meaning that we can expect that the annulment rate will eventually be in line with its in the commercial matters, which is very low, like below 5%.
Okay, but turning back to potential Ukrainian claimants, so the major concern of them, especially those who have some assets with Soviet roots for whatever reasons, is that after the Supreme Court decision, it's now the matter of arbitral tribunal to decide. Yeah, so it's substance. It's not for the French court to review whether it's Soviet or not Soviet, and whether it was done before or after 1st January.
Correct. And the benefit is that, as compared to other jurisdictions where this very question has not been asked in those terms, at least in France, it's decided. Yeah. And it's decided in favor of, let's say, of the investor.
Okay, that's great. Yeah. And you partially mentioned it, but again, that sounds a bit messy with all this setting aside and reinstating the award. So is it possible to enforce the award now, while the court proceedings are still pending, or it was possible even like all way before?
So, yeah, when the award was quashed by the Court of Appeal, it was nonetheless possible to enforce it, but not in many jurisdictions. Actually, the jurisdiction which accepts to enforce awards set aside at the
is France.
So set aside in France, so it's quite unfortunate in that way. But now the decision of the Court of Appeal is no more, meaning that the award is still there and it can be enforced from today because it's there. And of course, there is a pending, there's not even a pending challenge before it. It's for Russia to resume proceedings. So right now, there's not even a pending challenge of this award. And it is enforceable. And as long as the Court of Appeal does not decide to suspend enforcement of the award, which is very unlikely because they already said no once, it will be enforceable all along. So yes, we are back in a situation where the award is fully enforceable.
I have one more technical question before we move to next question. With regard to the decision of the Supreme Court, it's quite short, I would say. Is it like the full text, or it's a kind of summary and the full text will appear later? Just
no, you'll be surprised, Olena. It's actually much longer than it could have been before a recent reform aimed at rendering the decisions of the Supreme Court more legible for the public. Because before that, it would have been even more shorter, even less explanation. So there is what we call the principle of economy of means.
We have this principle as well. Yeah.
That the court will not say any word which is not strictly necessary for the decision. As a result, it is quite short, but you have the full decision in front of you. But it's entirely normal in the French system. There's nothing specific. It's entirely normal.
Okay, then that's fine. So we already have what we need, and what Russia could do to block it, because we know that Russian behavior in all these Crimean cases has changed. First it ignored it, like in Oschadbank arbitration, then it appeared in other arbitration, then it started challenging the awards, started blocking the enforcement. So what possible actions Russia could do now?
Well, it's for Russia to decide, of course, and I'm not going to speculate about what they're going to do. But they can certainly pursue their action to set aside. So they have to reinstate formally the action before the Paris Court of Appeal, which they have not done to date.
That means like a formal application, so it's not done automatically, even if there is a reminder.
They have to do it. Actually, they have 2 months to do it from the date of notification by bailiff. But it's an international notification, so it will take very long time. But they have 2 months to do it, otherwise it's lost. But the starting point has not started to run yet. But they can decide to do it earlier, of course. But it's for them to move now in front of the Court of Appeal. And then, of course, and Russia is used to doing that because there is a long line of creditors trying to enforce awards against Russia. They can resist in any jurisdiction where you're trying to enforce the award, first on recognition under the New York Convention, presumably, or local law if it's more favorable. So they can resist at this stage, and they can resist putting forward immunities. They are very sophisticated at doing that. Because we have a long-standing history of resisting enforcement of awards, so they are not short of means, but it's still much better than not having an award at all. It makes a huge difference because you never know. There are places where you can nonetheless enforce. So, but I will say no more, because then, of course, each, let's say, creditor is trying to enforce its own award. So there's a bit of a competition there.
Yeah. Now we have a queue already of successful claimants, even in Crimea cases. You just mentioned that the award should be notified according probably to Sahara Convention, but as I see from the judgment of the Supreme Court, Russia had an advocate in France. Is it possible to serve the decision to the party directly?
You have to go through certain formalities. This is not specific to this case. It is the way the French system works, and you have to go to certain formalities, and it's not good enough to have had a lawyer in the case, unless you have specifically accepted that that lawyer could accept service on your behalf. But by default, the default rule is that it's not the case.
Okay, then we will have some developments next year, probably. Okay, it's quite interesting and promising, I would say, for potential Ukrainian claimants, and we will closely monitor the developments in this case. I see that we don't have any comments from our audience, and with this, if you do not have any other comments you would like to share with regard to this case.
Well, I wanted to thank you for having invited me. As I say, I'm the face of a big team here. It's not only QE, Jérôme said, but also the Oschadbank team, which is fantastic, with the support of the ministry and the full country. So that's all. I mean, I'm just one person in a big team, and I would not want to take the credit for this team effort. That's the only thing I would like to say. It's very important.
This case is important in many aspects, and I remember that it was the first. It was pioneer in Crimea, and actually it made the way for other investors. Yeah, it was difficult probably to make the decision and to be the first and to argue the jurisdiction as a first claimant until any other jurisprudence has appeared. Now it's probably easier. And of course, in terms of amount of the award is also quite significant, and many other aspects of the case are really important and precedent settings probably for many other cases, potential cases, especially in view of this year developments. So with that, I would like to thank you very much for your time and for being available on short notice. We wanted to discuss this case when it's like hot yet and before the Christmas and New Year holidays. And I would like to thank our audience for being with us despite today's quite difficult day in Ukraine and all these missile attacks, etc. So thank you very much, and goodbye to everyone.
Thank you all. Thank you, Alina, and goodbye to everyone, and good luck.